Okay. Well, good afternoon, everyone. My name is Craig Nard, Director of the Spangenberg Center for Law, Technology, and the Arts. Welcome. One of the many virtues of being the director of the Spangenberg Center is that I get to work with tremendous people. One of them is Jabo Shabalala to my left, and not only work with him, but also be part of all the great things he is doing here at the law school, one of which is today, and the reason you are here. So I want to thank Jabo for inviting Preston, and Preston, thank you for accepting the kind invitation. Jabo will introduce Preston in a moment, but before he does that, just a few words about the topic that Preston will be visiting with you about. It's difficult to overstate the importance of this topic, this notion of the relationship between intellectual property and the creations, wealth, and resources of indigenous peoples. It's a topic that perhaps does not get the type of attention it deserves outside of the academy, but it's nonetheless quite deserving. And so I'm thrilled to have Preston here to talk about this topic and sort of for you to sort of be exposed to it and understand what some of the issues are in this very important area. So thank you very much for coming. And again, Preston, thanks so much for being with us. Jabo?
Thank you, Craig. So, when I was a freshly minted law grad in 2004, I showed up in Geneva, Switzerland with dreadlocks down to about here that were bright orange. And I had probably never felt more out of place. Clearly, I'd made a bad decision for graduation day, but I'd never felt more out of place than I did coming to Geneva to work in diplomatic environment with lots of stuffy suits. But the one place that I immediately did not feel out of place were the indigenous peoples and groups working on trying to find a way to vindicate their rights at the World Intellectual Property Organization. It was a group of people from all over the world with from many different backgrounds, and they were the only group in the room not wearing suits. And so I fit right in with my orange dreadlocks and no suit and big dashiki. But one of the things that has become clear at WIPO is that the work being done by indigenous peoples and nations at WIPO is probably one of the most dynamic, most interesting being done by any interest group at WIPO. It has posed a challenge to WIPO's, to the World Intellectual Property Organization's traditional mode of doing business, from working primarily with corporations to working with essentially human rights groups and groups that are making claims to sovereignty that are in conflict and in different sorts of relationships with the countries in which they operate. And one of the key people to the success that indigenous groups have had at WIPO is Preston Hardison. He's a policy analyst with the Tulalip tribes, but has played a much larger role than that in coordination, in generating positions, in providing advice, in working politically with developing countries and with indigenous groups, in helping to push for the recognition, for the protection, and for the reality of the rights of indigenous peoples at the World Intellectual Property Organization. Without much further ado, I think he has more interesting things to say than I ever could on this topic. Preston Hardison.
Thank you for those introductions. I'm just returned from Geneva. I was there about a week and a half ago on WIPO 29. And I've been at 26 of those meetings, so it's been a long session. It started in 1999 with a fact-finding mission. The actual discussion started in 2000, and it's been going since then. So let me lead you a little bit through this process. And what I want to do is talk first kind of about a more ancient context of these discussions. Then I want to talk a little bit about WIPO, take you into this a little bit about some of the other international dimensions of these issues, return to WIPO, and then return to the state of affairs in the United States. They're really all of a piece. Right now, one of the biggest problems, in my perspective, at WIPO is the United States, because it is pushing a very standard, conservative, intellectual property rights approach to these issues. And it holds the same perspectives domestically as it does internationally. So today I'll talk about Native American tribes, nations' rights to their intellectual property. Next slide. Oh, I have the clicker. I'm in control. And first I'd like to thank the ancestors of the Erie tribe for this opportunity to talk on their lands. I understand they're not around anymore, and maybe that should be kind of a lesson that we keep in the back of our mind. But any ancestors that are gathered in this room to hear these words, I am honored by the presence, and I hope for your charity, because I'm not of your tradition. Now, I want to take you back to the Junta of Valladolid, which many of you may know. When the New World was discovered, there was a big question about what was the status of these things that were found in the New World. Were they human beings? Were they savages? Were they worthy of rights? And so King Charles of Spain called together a junta of jurists to decide on the issues of the status of the Indians in the New World. And on one side was Bartolomé de las Casas, who was the Bishop of Chiapas, and he was a supporter of indigenous rights. He believed that they were rational, and he had introduced laws against what are called the encomiendas, which was a system of protection for the Indians in return for slavery. On the other side was Juan Gines de Sepulveda. He was a theologian, humanist, and philosopher. He believed in natural law, but in his mind he saw the Indians as barbarians, and because of their barbaric acts and ways of life, that there was a right of natural slavery, that it was right to enslave them, it was right to engage in just war, that the encomiendas were a good system, it was the best way to convert them, and he represented the interests of the colonists and landowners. The event ended in a draw. The encomiendas remained restricted on paper. But so Bartolomé de las Casas won in a sense, but actually on the ground the conquest of the New World continued unabated. Now, what's often overlooked in these debates was that both de las Casas and Sepulveda used the same sources and the same arguments. They just reached different conclusions. And in the debate, there was a lot of kind of public uproar going on at the time. And as they said, every man had his sentence. Every man had an opinion on the issue. And for somebody who's waded through several thousand intellectual property rights on articles on traditional knowledge, I feel like we're still in the Junta de Valladolid. Now, both sought conversion as well, whereas Sepulveda advocated violence to do this. De las Casas wanted to use the velvet glove to do it gently by model. And international law was weak, so even though the King of Spain, passed his edicts, it didn't make much difference on the ground in the New World. And so despite the words on paper, the slavery continued and the acts of barbarity continued and the suppression of the traditional practices continued. And so the lessons learned from this event was that both lost. The rights on paper did not lead to effective rights on the ground, and both were assimilationist in their approaches, and they really were bent on conversion to Christianity and conversion to the West's ways. They leave a question of what are the applicable laws and what happens when indigenous peoples and views are not incorporated into the debates. And again, I will draw the analogies with the WIPO process because I think they still apply. We are still often in Western juntas making decisions about the fate of indigenous peoples without their full and effective participation. So, now I'll turn to the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore, which is now known as Traditional Cultural Expressions. And the shorthand is IGC. It was established in 2000. It responded to developments in several forums, the World Trade Organization, Patent Cooperation Treaty, Convention on Biological Diversity, which had Article 8J and was dealing with issues of bioprospecting and biopiracy, and what became the Nagoya Protocol, the discussions on access and benefit sharing. There have been 11 years of discussions in this, 5 years of negotiations that are text-based on an instrument or instruments. So the actual outcome of this is not yet decided. It could be a declaration, it could be guidelines, it could be a treaty. But I think the important thing to understand is that it's potentially the first treaty that directly deals with traditional knowledge, traditional cultural expressions, and traditional knowledge associated with genetic resources. Now, when we started, we had a number of expectations in the negotiations. Of course, coming out of the Convention on Biological Diversity, we were concerned with biopiracy. Indigenous negotiators were looking for a sui generis regime of its own kind. Now, what is sui generis? Well, actually, when we use sui generis, we were referring to customary law. We were actually referring to something that was not sui generis. It was just sui generis within the Western system. So we were trying to get recognition of indigenous customary laws as a valid form or template against which harm could be measured. So we also wanted the recognition of cultural harms and indigenous rights. So it's a rights-based regime. And we were trying to get this recognition. Now, unfortunately, having just returned from IGC 29, I can say this is not yet realized, and there are some big questions on whether it can be. The IGC was suspended last year because they could not agree on a way forward, so they didn't have a mandate. The mandate was renewed this year, but apparently the year off to do some thinking and do some homework and some communications with the parties didn't work. There's been no real convergence in points of view. Indigenous peoples get support among the developing nations, but this comes with entailments. Their issues are not entirely the issues of indigenous peoples. One of the big issues they have is the development agenda as defined by WIPO, not as defined by the Millennium Development Goals or the recent Sustainable Development Goals. And they really are interested in the national economic development aspects of traditional knowledge and TCEs and genetic resources. The developed countries like the United States, Japan, South Korea, and others are really viewing this as requiring only marginal changes in the existing intellectual property rights regimes. And most of their arguments are around how to narrow or minimize the changes in the existing regime. I would say that they have shown actually very little concern for the actual holders of traditional knowledge, that more of their concern is going towards the companies, towards third-party rights and civil rights and access to traditional knowledge. And also, this is all happening in a world where their domestic regimes are absent. So this is kind of an unusual set of negotiations. So instead of building a regime from the bottom up, where you have a solid base of experience and understanding to work from, and you also have a public and a legal system that understands and responds to the issues, we're trying to build it from the top down, and it's really not working very well. So things are being decided, and I would also say this is the same issue in the Nagoya Protocol. Now I'm going to switch very quickly, before going back to the IGC, to the United Nations Declaration on the Rights of Indigenous Peoples, because This is an important frame in which we believe these negotiations should be taking place. It is an aspirational document. Parts of it do reflect, we believe, settled international customary law. But in terms of what the states believe, it's a little bit different. The United States has signed on to it, but when they and Canada and Australia and New Zealand signed on to this document, they had what are called signing statements, where they clearly said this is aspirational and we don't necessarily accept any part of this. We believe it's a good idea, but we're not bound by any of it. But in order to frame the UN Declaration, first of all, I think you need to understand that it was actually built on the Universal Declaration. And what happened in the Universal Declaration, which is an individual rights-based document, it was quickly realized that the individual rights were not enough to deal with the special nature of the collective rights, and also didn't adequately protect minorities. And so that in order to have equal rights, actually minorities sometimes need special protections to make sure that the tyranny of the majority doesn't overwhelm their rights. And again, it's not built on special rights. It's just here, it was a way to implement universal human rights in these situations of, highly marginalized peoples. There were special attention to legal principles to prevent the continuation of conquest and suppression, cultural and economic domination of these peoples. If you'd like to see, this will be up online. I'm sure we can have it arranged. And I don't mean to kind of talk all this through. People should go to these things. This is a resource that has several different human rights documents and kind of carefully goes through where the rights come from and where they can be found in the various human rights documents. So it's a concordance between UNDRIP and other human rights documents. It's very useful. Now, many of you may have seen this. If you have not, it's one of the most important in terms of the intellectual property rights. Article 31 of UNDRIP says, Indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, etc., etc. And I want you to focus a little bit on the word control, because control is the one piece that is left out of most of the discussions of WIPO. There's some understanding of maintain and protect and develop, but in terms of control, WIPO is not quite there. And again, we have our supporters, but there are still many that are not converging on that. Okay, now let's return to IGC. I think there's I want to frame the discussions in terms of some large category mistakes. And these are the same mistakes I find in the legal literature again and again. I will have to say, in my opinion, much of the legal literature in the journals is not helpful. Why? Because I believe it starts from the wrong place. You need to start not from the Western intellectual property system and work down to the indigenous peoples, but you need to start from the indigenous peoples' systems, try to understand, and see how far you can go to accommodate those systems within the intellectual property regime. And so it's starting from the wrong direction. Now, traditional knowledge is not information. Traditional knowledge is a way of life. In the minds of the holders, often they believe it comes from the Creator, it comes from the spirit world, it comes from the ancestors. It's a gift. And it's a gift that has to be used wisely and used appropriately. And if it's not, it will be taken away. It will be withdrawn from you. It's also not abstract. It's not CD-ROMs, it's not music, it's not computer code. It is about things on the ground. It's about subsistence, it's about your identity, it's about your human dignity. And when you talk about traditional knowledge, in indigenous minds, they often refer not only to, inalienable rights, which is the focus of many activists, but actually they focus on inalienable obligations. And there are some good authors, I have their names at the end of the slides, that have referred to these as stewardship obligations. Now, the fundamental point of these are they're permanent. They don't go away. They are never exhausted. If I, as an elder, pass knowledge to you, you now inherit a burden on that knowledge, that you have to use it in the way that it was intended. And this is a stewardship obligation. And when you in turn pass it on, you pass on that stewardship obligation to another. And this is a very common sentiment that's been, if you go through indigenous writings, you'll see this stewardship concept related to knowledge as being extremely important. And that's why we say the public domain is very problematic for indigenous peoples, because that's the area where all rights have been exhausted and there are no obligations to the originators of the knowledge to use it in a particular way or to share benefits or to whatever. So there are indigenous contexts to sharing traditional knowledge. And understand that it has many facets. The traditional knowledge is not just one thing. As a matter of fact, I think in a way it was a mistake to invent the phrase. Because if I use traditional knowledge with indigenous peoples, often they know I'm not from around there. It's the first thing they know. Because that's not the way they express it. They say, this is the way we do things. This is the way it is. This is the way it was intended by our ancestors. And so it is really just this whole way of doing things, and some of it may be highly secret and sacred, and some may be more open. So don't think that, all traditional knowledge will be created in one way, and that it all has the same characteristics. Now, I will say that in my experience, most of it does have a spiritual basis, that they will say, again, we have these obligations to the spirit world. And using it actually links you to the spirit world, and it's an active principle. It's not just kind of a feeling or emotion. So when you approach these issues, try to, avoid essentialism and assumptions. Don't make assumptions to what indigenous peoples want. Ask them. And it may be different for different kinds of knowledge. So I'll give you an example, the idea of what is the meaning of protection. IGC is working on the protection of traditional knowledge, but protection from what? What do you mean by protection? Well, that's a highly equivocated term in the literature. It's rarely discussed as to exactly what it means. I won't go through all of these. Again, they're available to you. But sometimes it's you want protection using the Western intellectual property system. But more often, they're looking for protection against the Western intellectual property system. Sometimes they want protection against the granting of private property rights. Sometimes they want the protection against extinction. Now, if you want to be protected against extinction, what do? You spread your knowledge around. You get it in as many minds as you want. But that may not be what they want. The elder I first worked with said that he had a duty to take his knowledge to the grave if it wasn't going to be used wisely. And again, in his mind, because it came from the spirit world, it was not really lost. It was still there. Sometimes it's protection from use by outsiders, protection from commercial use, protection from commercial use without compensation, or protection from non-commercial use. And again, I think I've run across many papers, especially by commons peoples, that believe, indigenous peoples don't own property, this is part of the global commons, and they probably want it to be used, non-commercial use is okay. Maybe it is, but maybe it isn't. Again, ask them. Okay. Now, in the negotiations, there are two major forms of protection that have been discussed. One is what's called, quote, defensive protection to prevent third-party acquisition of rights, and that may be through use of databases, documentation, public domain, and prior art evidence. Now, this is a very, very narrow understanding of defensive. As we've pointed out many times, we have to be careful that the mechanisms which are common under the intellectual property system and work for secular Western knowledge don't necessarily work for minorities and for people who have spiritual and sacred knowledge. So, say you want to protect your knowledge from being patented. Well, you put it in the public domain. You show that there's prior art. The problem with doing that, by putting it in the public domain, you've now made it open to petty uses. Maybe you've prevented monopolistic uses through patents, but now you're opening up for petty, non-monopolistic uses. You haven't really protected against commercial use either, because by putting it in the public domain, somebody can exploit it commercially and they don't have to share benefits with you. It's just that they can't do it exclusively. That's what you've done when you put it in the public domain. The other approach is positive protection, which is affirming rights to maintain, control, and protect traditional knowledge and traditional cultural expressions, and we focused on those. And I will move from there. Okay. Others are category mistakes about what the objectives are. Again, the states have been very quick to agree to non-interference principles. So they'll say, okay, if we patent it, we're not going to interfere with your ongoing and existing and prior use. And they think that's a big accomplishment, and it may be if that's what indigenous peoples want, a particular group for their particular knowledge. But they may actually not want others to use their knowledge. So saying non-interference isn't necessarily a complete solution for them. And the protection that is offered is often limited to patent, copyright, and other IPR issues. We've taken an all rights approach where we believe you should take into account all the rights that apply: human rights, treaty rights, constructive arrangements with states. And the first principle is do no harm. And as I said before, the idea of defensive protection through exclosure into the public domain, we've given the example for the Tulalip tribes. They're not really threatened by unjust enrichment by Pfizer in Switzerland. What they're really threatened by is when people find out about the use of their traditional resources, they go and they harvest every single one of them. And they leave nothing behind for the bear. They leave nothing behind for reproduction. And that's really damaging to the culture. So we've said your solutions that you find in the IPR system against some of these threats, the cure cannot be worse than the disease. You have to prevent harm. There's also this issue, which some of you may be aware of. The phrase in the IGC is indigenous and local communities. And as I said, the United Nations Declarations on the Rights of Indigenous Peoples was passed because there's a recognition that there is a subject of international law, which is indigenous peoples with an S, which are people who have rights, self-determination and self-governance rights. Local communities, there is no international law of local communities. And I could spend a whole hour on the complexities of this. Nobody's throwing local communities under the bus, but in terms of bundles of rights, they may have a very different legal status. They certainly do in the United States. The negotiations are laden with geopolitics. A lot of it is World Trade Organization payback. There was a lot of promises to the third world of the benefits they would get through the WTO. They didn't really materialize. And also it's trade driven, that a lot of the issues, while they're there ostensibly to talk about traditional knowledge, is really about the cultural industries and trade. And so there are a lot of issues being piled in behind the scenes. A lot of the discussion is not really driven by the U.S. Patent and Trademarks Office from our side. It's really more driven by United States trade. And if you don't understand that, then you're not going to be able to effectively deal with some of the negotiations. You know, effectively, the United States does not want to pay for the use of the name Kung Fu Panda, okay? That they don't want to say, because pandas only come from China, that China is able to then put a tariff on the use of the word panda. And same thing with Kung Fu. Okay. Now, I'm going to talk about the different segments. There are 3 segments. I'm actually just going to talk about 2. There are the discussions on genetic resources and discussions on traditional knowledge I'll briefly mention traditional cultural expressions, but because of time, I will have to miss a bit of it. After 15 years of discussion, all we have on the table right now for genetic resources is two approaches. Disclosure of origin, which means that companies have to disclose where they got their genetic samples, and databases of traditional knowledge. Now, that's not a lot to go on. And the whole purpose is to prevent the granting of erroneous patents. Now again, like I said, I understand, for example, databases. Prior art databases is the primary way that the patent system is able to acquire information about prior art so that a bad patent can't be granted. But that's related to secular information, not this spiritual kind of information and with all these cultural issues that indigenous peoples hold. And again, also, as I just said, indigenous peoples may have recognized self-determination, self-governance, and in the United States, they have sovereignty rights that others don't have, and these political differences make a difference. So, disclosure of origin puts the burden on the users, the companies, to document legitimate sources of their traditional knowledge associated with genetic resources. And disclosure is supported by many countries, and interestingly enough, the European Union. And I mention them because they're typically allies with the United States on intellectual property issues. But they've just passed legislation that requires you to document where you got your genetic resources from. Now, the U.S. has said this is a burden on corporations, and this creates a high degree of uncertainty, and they are very strongly opposed to disclosure of origin. There's been some research. A friend of mine, Paul Oldham, has recently done some extensive research on patents and shown that it is actually common practice to do disclosure. And then there's a question of, well, how much are corporations actually harmed if you take a certain number of genetic resources in collections that do not have source data and put them off the table? The U.S. says, oh, that's going to be a huge burden. We know that a corporation, for example, can go into the oceans, spend about 2 days trawling in the nearshore area, and haul up enough microorganisms where it may take them 5 to 10 years to run through all of those to do an assessment. So are they really biodiversity limited? Are they? So that's a big data question that has not really ever been answered. The alternative is these giant databases. The U.S. has said there should be an international database of traditional knowledge. And we've raised a lot of questions with these because, first of all, who's going to compile these? Who bears the burden of compiling these databases? These databases are precautionary, so they're done before any crime is committed. They're just like, okay, we're going to register everybody's fingerprint. And so, the idea is just to register a huge bulk so that if a crime occurs, you have on register the fingerprint or the grooves on a bullet or whatever for your evidence. Now, this is a huge burden on indigenous peoples, again, who have all these cultural issues with documentation. Some, it's an oral culture, and some elders say it's not appropriate. They will not put that kind of information in a database. Now, the U.S. has also said, and its allies have said, well, we'll make these private. They'll only be open to patent review agencies. And I've pointed out in the United States this isn't really possible because we have a famous case called the Klamath Water decision from 2001. Supreme Court did a review of some knowledge that it had, information that it had. It wasn't traditional knowledge, it was just water information, but it had a memorandum of agreement with the Klamath tribes to keep it private. Farmers Group found out about it, petitioned to get access under the Freedom of Information Act. The tribes claimed they were protected by Article 5. Supreme Court said, you're not protected by Article 5. I'm sorry, you're subject to the Freedom of Information Act. Now, they did say, you're not barred constitutionally from being protected, but until Congress acts to protect you, you're not protected from the Freedom of Information Act. So at this point, the FOIA laws have not been amended. So if the United States has access to that, and especially if they paid for it. There are other laws that come into play for example, publicly funded information acquisition and generation. There's no protection. So, and then also with this latest one, some people started saying, well, maybe they should be open to corporations and maybe they should be open to citizens. So, even their first premise now is starting to evolve, just as we warned early on. So there are a lot of issues with the compilation of these databases. Once acquired, they become a target for theft, corruption, and we just have to be realistic. There's the flip of a switch issue as I call it. They're really not protected by computer security. I don't really believe that's a long-term protection. They're protected by policy. And all it takes is a shift in government, a shift in laws, and suddenly after you've collected all of this, you just flip the switch and now it's open. So we've got major problems with the database issue. It's a big burden for indigenous peoples to document their knowledge. A big bombshell at the last meeting that just happened was the definition of misappropriation. One particular member, I will not say who, introduced limitations on the concept of misappropriation, and they said, one, if you reverse engineer it, it's not misappropriation. If it's already published in the literature, using it without permission is not misappropriation. If traditional knowledge holders have not taken steps to protect their knowledge, and you use it without permission, it's not misappropriation. So that's a trade secret-like rule, and they're trying to make indigenous peoples conform to Western trade secret laws. As we pointed out, trade secrets are held by brick-and-mortar institutions, not living cultures. And it's living cultures that socially regulate the use of their information are very different from brick-and-mortar institutions with lots of lawyers and contract law. On remedies and penalties, again, several members rejected the idea of patent invalidation. They said, well, that would increase uncertainty and would be unfair to the poor corporations that have done research and development on potentially illegally gained resources. And so we responded by saying it's probably not a good idea to not have the invalidation of patents in the case of willful misappropriation and malfeasance. There is some support for coercive benefit sharing that says, should you do your patent on something that you, based on illegally acquired genetic resources or traditional knowledge, we won't have your patent validated, but we will give you a fine to make you share some benefits, which again to us seems like a license to misappropriate. Corporations likely can afford at least monetarily. We think there's some protection in that a good company is not going to risk their shareholders by doing such things, but we don't think that's a good principle to force benefit sharing for these kinds of bad patents. Okay, there's a question about the status of traditional knowledge used in patents. In the normal course of affairs, you publish a patent and everything that was needed for the working of that patent is immediately available, and then after 20 years it goes in the public domain. And this is kind of a problem for indigenous peoples who may have held useful knowledge since time immemorial within their small-scale societies. There's a question, do indigenous peoples have the capacity to include only what's necessary for the working of the patent? And do they have the capacity to monitor the patents that are coming out and find and potentially prosecute the malfeasance doers? I guess that's not a word. Okay, I'm 18 days on the road, so please. Traditional knowledge. Now I'm going to turn to the traditional knowledge section. There's kind of a problem with these. Again, some of the same parties who shall not be named. There's a focus on inappropriate third-party rights, which itself is appropriate. But there's also some language in there that focuses on protection of freedom of expression, protection of a vital public domain, protection of fair use, protection of the common heritage of mankind, the protection of existing third-party rights, and state protection against retroactivity. And if you're discerning, you will understand that these are all principles really to divest indigenous peoples of rights to control access to their traditional knowledge. These are common principles in application to Western knowledge. As I've tried to point out, they're not appropriate under customary law, and they may not be appropriate when you're dealing with extreme minorities that have very different values, very different customs, and also are now in a world of 7 billion people with the internet. There's also been a change in the approach. When we started, most of the parties were really interested in protection against the acquisition of third-party rights. There's now a major move towards rent-seeking to get economic benefit out of traditional knowledge. And let me see if I can, there's a couple of things I want to emphasize. Again, freedom of expression, vital public domain, fair use. These are all principles to allow a public to have access to traditional knowledge. And again, the interest here is to protect the rights of non-holders as opposed to the rights of the holders of traditional knowledge. Okay, on beneficiaries, well, you would think it would be indigenous peoples, which is still in a bracket, local communities, but we've also recently had the entry of states as being beneficiaries. So states now are claiming they can be both holders and owners of traditional knowledge. Again, this is part of the rent seeking, but also it's really the Francophone states, and if you know, the Francophone inherit a legal system from France, which really, égalité, fraternité, liberté. Égalité is primary, and they make no distinctions about higher and lower, which is why they've had so many problems accepting the idea of indigenous peoples. So they really say we have a constitutional bar against recognizing indigenous peoples or local communities, and we are trying to build a national identity, and therefore states can be holders and owners of traditional knowledge. And this is really creating some havoc with the discussions. There's a question about the nature of rights, and remember I started talking about the questions about which laws apply. I will say the United States introduced this one, literary and artistic works. So as I said, traditional knowledge is not information, and I will say categorically traditional knowledge is not a literary or artistic work. The U.S. introduced this because it ties it to the Berne Convention on artistic and literary works. This is copyright-like language. This is intentionally put in to kind of bind this to an intellectual property regime, not a sui generis regime. The second approach now that we've been discussing is called the tiered approach. Now, I support the tiered approach, and that's kind of our common understanding that intellectual property rights come in degrees. That there are some that are very strong, where you have very strong protections, then you have weaker, and then weaker, and then weaker. But right now the tiers are secret and sacred, closely held, and widely available. And if it's widely available, you don't get protections. And so I've made the point that Lady Gaga's music is widely available, yet it's highly protected. So just because it's widely available, I would argue, is not the appropriate test, the legal test. So you need an in-part legal test to kind of decide whether, how much protection it should be given. Now, secret and sacred may work, but I think some better tests are, for example, intent. What was the intent of the indigenous peoples? Did they want it to be in the public domain? Did they want it to be spread about? Yoga was taught, and Ayurvedic medicine was taught in universities for over 1,000 years and deliberately spread throughout the world. That's really different than the Tulalip tribes, which has held ceremonies within the Longhouse and doesn't really have much of a tradition of sharing with outsiders. So I think intent should be an important one. Customary law should be an important test. Is there a customary law that talks about how this is secret or sacred or not shared with outsiders, or limited to a family, or limited to a clan, etc.? And then also the idea of risk or harm, including cultural harms. And we've had a real problem getting cultural harms recognized in Western intellectual property law, Western law in general. Because again, the Western system does not believes that recognizing cultural harm sometimes is establishing a religion, because you're protecting a cultural belief. I really would love to go into that, but I don't have time. I don't think it is. When I visit another country, I'm expected to follow their laws. I don't have to believe in their religion or their practices, but I have to follow their laws. Okay, exceptions and limitations. This is a very important and grievous part of the negotiations. Again, I will say the United States is pushing unconditional exceptions for libraries, museums, and non-commercial research. This is not existing practice. Museums are working with tribes. They are working with indigenous peoples now. It's more common that they are working to make sure that only things that are appropriate to show in a collection are shown. It's working to maybe pull from general circulation. In Australia, for example, when somebody dies, it's not appropriate to look up at a picture of them if you're from that culture. So what they do is they pull the books from general circulation, create a special reading room. You have to get permission from the owners of that picture and that traditional knowledge to read that, and you get a document to say what the purpose and so on is. So you're not prohibited, but you have to have a contract to specify what your use is. So there are all these protocols people are following. And as we've said, there's this idea, and I think Western society, that if it's non-commercial, it's okay. And for indigenous peoples, that's not necessarily the case. There's a very strong focus on protecting third-party rights. This is a real issue. In my mind, we have now 500 years of contact in general. In those 500 years, there has been a lack of recognition of customary law of indigenous peoples, of their basic rights. So the Western system, is ever since the Scottish Enlightenment philosophers have this philosophy of intellectual property law. They defined most of traditional knowledge and traditional cultural expressions as being in the public domain. So people have acquired third-party rights over it, and they're not really, being bad people. They thought they were getting valid rights, and the government said you are. So we have a real problem. How do we deal with these third-party rights? I'm going to quickly tell you about my idea of progressive repatriation. Very timidly, this is not part of the IGC, but I think we can deal with this. It's based on the progressive realization of human rights and the human rights system. It's saying, well, we may not be able to get rights back right away, but can we find a way to progressively repatriate rights to indigenous peoples? Number one, Golan versus Holder was a decision a couple of years ago. It was based on the Uruguay Round Agreements Act, which put certain works that had fallen in the public domain back into copyright, and the U.S. was required to comply. That case went to the Supreme Court, and there were two interesting things out of the Supreme Court on that case. First one, you need to respect the treaty because that's the supreme law of the land. And remember, at least in the United States, the Indian treaties are the supreme of the supreme laws of the land. They were made prior to most other treaties, so they are first in line. The second thing is that they said, and this is very weird coming out of that court, no public expectation of the public domain. It was okay to reprotect these things. So we believe that there are ways to kind of deal with the third-party rights, because what's their nature? First of all, they can't really be moral rights. There might be a little aspect of moral rights, but they're really economic rights. So let's just say we don't interfere with the economic rights. We let them play out on existing users of traditional knowledge or traditional cultural expressions. Let them play out. At the end of their term, instead of going into the public domain, the rights revert back to the indigenous peoples. Now, so the economic rights are not harmed, but we would say for new entrants who want to make economic use, they have to get prior informed consent before they can get the use. And maybe the consent would say use it freely. Sometimes they'd say we want benefits, but that's up to the indigenous peoples. There also, we could harvest low-hanging fruit, so there are orphan works, and also authors could dedicate portions of their works that come from indigenous peoples back to them. And so over time, if we're patient, I can see a system where we can continually revert the control of indigenous rights. And this is probably pie in the sky, but seems kind of reasonable way to deal with the third-party rights. Yes?
So under your theory, when the orphan rights or the rights that have been, re-given to recoming the copyright law, after the expiration of that term, instead of going into the public domain, they would give it back to the indigenous people by some...
Right, they would have to identify it, and again, there's a big question. The Library of Congress, for example, has expressed a major concern, which I understand, that boy, are we going to have to go through our millions of books and discover traditional knowledge and find its owner. So I would think it would be an opt-out system rather than an opt-in system. So if
went through a lot of different scenarios about orphan rights.
Yeah, well, I'm not saying, these laws take a long time to work out. They're not easy. What I've suggested at WIPO, for example, not get to be too prescriptive and to really work on a framework convention will be a lot better than trying to get into a lot of details, because, remember the Paris Convention, I think, was a paragraph or two long, wasn't very long. Okay. And then also as an aside, you may have, there's a growing commons movement about contract law and then Creative Commons license, and some people are pursuing that. And the nature of some of these IPR approaches actually are contracts. There's an interesting case that has been missed by the indigenous crowd, and I can understand because it was about model railroad software. Jacobson versus Katzer, where a open source license was violated by, I can't remember which party it was now. So it went to court. And the judge had to decide what is the nature of these contracts. Are they something that is an alternative to copyright, or actually are they just a modification of underlying copyrights? And the judge reasoned that they had to be a modification of underlying copyrights. Otherwise, you could just use the contract system to supersede all the copyright system, and that would really undermine the copyright system. So we have this decision. It's just a federal court. It's not the Supreme Court, but it's still pretty high level. And that says that once the copyright and the contract terms diverge, the copyright actually takes over and has supremacy. Which means that if you have a contract to protect traditional knowledge, it may only last the term of copyright, and then it goes in the public domain. So it argues that you need specific laws to deal directly with the Aboriginal rights. Finally, there's the balancing test, that when we restarted negotiations, there was some new language that talked about creating balanced and effective negotiations, or effective and balanced, one or the other. The word balanced is kind of a target word for me because there are many senses of balanced. But for us, as I said, we had self-determination rights and human rights. And whereas you balance the civil rights of stakeholders of equal standing within a society, what you don't do is balance the rights of citizens of one society against the rights of another society. And when you talk about human rights, you have to be very careful about balancing civil rights against human rights. You don't balance civil rights against slavery. You don't balance civil rights against some of these egregious harms. And we're really concerned, as we saw once they put in that language, the number of corporations in the room increased by about 20%. Okay, so I'm running out of time. Oh, I'm going backwards here. I'm going to skip traditional cultural expressions, as I said, and now I'll get to domestic and finish up. So these are critical issues in the United States. They're not limited to intellectual property rights. I work for a natural resources department, and because the U.S. Patent and Trademarks Office right now is the only office that claims jurisdiction over traditional knowledge, it affects my ability to do natural resources management. Why? I can't even talk with the U.S. government and share traditional knowledge, because if I do, I know about it's going to be handled by FOIA or it could go into the public domain. Once I share traditional knowledge across the Tulalip tribal boundary, at this point, I know that it's not going to be protected. So again, I can't engage in lots of conversations because of that fact. In the U.S., there's very few other laws that deal with intangible knowledge. The Indian Arts and Crafts Act, and it only protects against passing off. Native American Graves and Repatriation Act has a little language on intangible cultural heritage, but it's not strong. So the USPTO gets the lion's share of the jurisdiction. So given the failure of the IGC over 16 years, tribes are considering domestic law approaches. We've kind of failed on the international front. We'll still continue, and there's some hope. David and Goliath. But one, understand tribes are sovereigns in the United States. Well-settled law from 1823 to 32. The sovereign rights are inherent in the land. That means they're not granted rights. They were not granted to the tribes by the United States. They had them prior to the existence. We have the canons of construction of Indian treaties, which says they need to be understood as the Indian signatories understood them, constructed liberally in favor of the Indians, and any ambiguities have to be resolved in favor of the Indians. We also have treaty interpretation, which is narrow construction. Sovereigns do not give up their rights lightly. They only give them up explicitly. You cannot have kind of accidental and side effect loss of sovereign rights. So under treaty interpretation, it's just not even Aboriginal treaty, it's straightforward treaty interpretation. So tribes have what are called reserved rights. Treaties are not about listing all your enumerated rights. They're about listing what you cede to another country, what sovereignty you allow to be ceded, what obligations you assume. And in the case of the tribal treaties, it was mostly land in return to keeping the peace and maintaining their cultural ways as they saw fit. There was no explicit cession of tribal authority over traditional knowledge in the treaties. As we understand it, the main purpose, again, was cultural, and that would have included traditional knowledge, which is a core part of their life. We have the explicit abrogation doctrine, which says that if a tribal right is going to be abrogated or terminated, it cannot be done accidentally. And we've looked through the record and we find no example where the Congress has explicitly terminated tribal rights. It's rarely even considered traditional knowledge. It did in an Agricultural Appropriation Act of 2008, where it exempted traditional knowledge related to sacred sites in national forests, and that's it. There is a Native American tribal insignia database that was created out of a public law that said look at insignia, but it just said look at insignia and deal with it. So we have very narrow looking at traditional knowledge, and that's what we're going to be doing in the near future here. Most people in the United States don't know this. It's not been touted around, but there is a policy on traditional knowledge. That was Del Laverdure said it at a Senate oversight hearing in 2011. And then David J. Hayes wrote a letter to the Tulalip tribes reaffirming it. And the policy is the federal government generally supports that the tribes in their understanding that it is their sovereign right to protect tribal cultural heritage and cultural identity expressed in both tangible and intangible forms by developing tribal laws. So we have a battle now between Interior and USPTO, maybe not battle, but a disagreement. So I think there's not much. I need to have some time for questions. Let's just say that, what we're trying to do is get a recognition that tribes did have their own laws and customs. And we're trying to see is how far can we accommodate these in U.S. law. We've never really tried. We need to try harder. And tribes need to be supported in their efforts to develop their own comprehensive intellectual property rights codes. Thank you very much.
Thank you. You started by stating first we have to ask somebody, what do you want? And that may differ or will differ depending upon the particular cultural heritage or whatever. And you also said we can't start with Western views and try to apply it. What if, and this will undoubtedly happen, even if you achieve almost everything you're looking for, what if the dispute is between two indigenous peoples who claim, if I can use that term, a particular heritage, and as best as we can tell, they differ as to what should happen, whether there should be third-party rights, whether that's an issue, whether it should be disseminated, whether it's in the public domain or not.
Well, I think in those cases, at least in our condition, and again, UNDRIP actually says that other indigenous peoples have the same condition. But I only speak to ours where we clearly have a treaty system. The tribes are sovereigns, and if they disagree, and one, it's clearly, if disclosed by one, it's disclosed for all. And that may happen, and there may be nothing we can do about that. What I see in these processes should be built in an alternative dispute resolution mechanism. And tribes actually do have their intergovernmental organizations. As this evolves, I can see, for example, the Coast Salish, which have a lot of knowledge shared because of their history of being, Coast Salish peoples, could band together and then have cooperation to see where they want to go. And just like in fishing disputes, tribes sometimes want to go their own way. That's going to be inevitable. But I think it's a better system than, right now we focus on the individual. Whenever I intervene in the IGC, the U.S. tends to, you can see it if you go to the IGC website, we just had a meeting and there was a webcast. And if you look at the webcast, it had Vicky Tului-Corpuz, myself, and a gentleman from the Pacific Islands. At the end of the thing, we had questions and answers, and the very last question and answer from the U.S., and I'd really highly recommend watching that because it really reveals the thinking of the U.S. Because all of their examples are, well, what if an individual wants to go and reveal this knowledge? Isn't their right as their individual to do with whatever they want to with their cultural heritage? And we would say, well, individual rights within indigenous groups are still affected through a collective. And so you may have wide rights within a collective, but you may not have the right to actually reveal to outsiders. So you as an individual may have some rights to circulate knowledge within the community or within a set of related communities, but you don't necessarily have the right to share it with outsiders. And then the second thing is, I don't want to make too much of a fetish out of customary law. At least in the United States, tribes have the right to pass laws, and just like anybody else, they have the right to cultural security. And what's happening now, again, if you're in a world with 7 billion plus people in the internet, it becomes so trivially easy for one kid to take their iPad and hit record, and then a few seconds later hit post to Facebook, and boom, it's out there. So in order to protect themselves as minorities in an ever more hostile world, you might want to also allow for modern tribal law to come into play. Because again, it's, the idea of cultural, customary law and so on, the right to have your culture wasn't to put them in a bell jar, but to have self-determination over their evolution. And so there are also laws we might want to pass. Carvers in our area used to share with outsiders. They don't anymore. because of too many outsiders taking the knowledge and setting themselves up as master carvers and taking business away from the carvers. So I don't know if that answered it, but you know, it'll still be a leaky system, but I think we can find ways to see others' rights. Yeah.
In my research, I found that a lot of the tribes are pushing back against coding anything in the first place, and so I was wondering if you could speak a little bit about that and how to navigate that.
Well, like in the genetic resources, we said you know, I don't have to give you a list of all my property in order to be protected against theft. If somebody steals my stuff, the cop can't say, well, you didn't list it all. It's useful, but there are other means where you can generally describe what your stuff was, and if they find something, a pile of stuff that matches that general description, that can be protected. So, you know, we will have to make a distinction between ex post and ex ante approaches. I think disclosure by our, you know, databases, there may be some that can go in, and it does help as an ex ante to prevent theft in the first place. We have been pushing disclosure of origin primarily because it takes the burden of documentation away from us. It says if you're going to do development, don't steal. and just make a statement you haven't stolen, and then if you've lied about it, you should be subject to a very, very severe penalty that could include revocation of your patent. So it's a problem.
Unfortunately, we are out of time. However, we're going to have a reception with drinks and food outside. So if you have any more questions for Mr. Hardison, I'm sure that he'll be happy to answer. I'd like to thank Mr. Hardison for coming here today and speaking to everyone.
So the reception is just around the hall in the lobby over here. We'll be right there in a couple minutes.